Got it.
Welcome, folks. This is House Corrections and Institutions. It's Friday, February 6th. We have with us our legal counsel, Hillary, walking us through draft 1.1 of proposed changes to a current program that's in place, pretrial supervision. These changes are reflective of what the Council of State Government has recommended. And before we get started, did you check to, well, does this also incorporate any of the administration proposed changes? I think it tracks the Council of State Governments, their changes.
I have not checked to compare.
I'll check as we go along. Because the administration has some amendments to this that is over in Judiciary Committee, so I will track as we go. I think I looked at it quickly, what Judiciary had, what the administration proposed, and I think it's all the same.
So for the record, Hillary Cheddar Ames for the Office of Legislative Counsel. The bill that I'm aware of in House Judiciary is 529.
I heard 410.
Okay, I will double check 410 as well. The one that I'm aware of.
Maybe it is 529.
Okay.
Yes, it is.
Okay, the language from 529 is in this bill.
Okay.
It's one small change, and I'll point that out when we get there for the committee's reference. So as the chair mentioned, this draft bill attempts to implement the 4 key recommendations that the Council of State Governments made in its presentation to the committee. The language in the bill is not from the Council of State Governments, but it's a place to start in implementing their policy recommendations from their presentation. So quick reminder that they made 4 recommendations. One was to fund dedicated officers who maintain caseloads of no more than 20 clients. 2 was authorize DOC staff to make direct referrals to the courts in response to condition violations. A reminder that right now, DOC staff can tell the prosecutor that a violation has occurred, but DOC staff cannot go directly to notify the court. It's kind of the prosecutor's the middle person in that process.
And they can also do that already with post-conviction.
Yes. Yep, that's my understanding.
Yeah.
You're talking probation, right, Troy?
It's not, they currently don't have the authority they need to
Do that in a
more
pre-trial
immediately
context.
respond.
Right, but you're saying they have that authority in
Yes.
probation.
Well, I don't know. I know it's post-conviction, so they would have it in probation.
They would have it in furlough automatically
Yeah.
because they're under DOC, and then they would have it in parole to go to the parole board.
Yeah, yeah. So they do have it in probation. They have it post, yeah.
Correct, that this authority would not be an entirely new concept.
Right.
That DOC staff are able to do that in a kind of parallel post-conviction context. The third recommendation was to refer people to the pretrial supervision program based on relevant factors with a focus on risk and needs, including behavioral health and substance use screens. So remember that currently there are 2 requirements in the statute for someone to be eligible. Someone has to either have charged with violating a condition of release or have 5 or more pending dockets. So one of those 2 things, at least one of those 2 things has to be true for someone to be eligible to be referred to the program. And the recommendation from the Council of State Governments was to shift from those requirements to having DOC assess who the program would work for based on some of the screening tools that Council of State Governments talked about. The fourth recommendation from Council of State Governments presentation was to direct the relevant health and human services agencies to develop a streamlined method for referring pretrial supervision program clients to behavioral health services. Those were very needed, and that there were some challenges in making them available.
And that's recommending them to your community partners.
Exactly. So if the committee wants to reference, these are from the PowerPoint slides that the Council of State Governments used in its presentation. But those 4 recommendations are what the bill attempts to implement. And I'm sure you'll hear more from witnesses about the right way to implement and whether some of these should be implemented, but this is at least a starting place in bill language. Any questions before we turn to the bill language. All right. Oh, yes.
No, I'm sorry, I'm just
Okay.
looking at my notes quick, and I think you got it all though. You did.
Happy to have anyone add or correct as we go along. So on page 1, this is draft 1.1. It doesn't have a bill number yet because it's a committee bill draft, but the draft request number at the upper top left is 26-0762. So this bill is working in one section of the statute. If you remember, 13 VSA section 7555 is where all of the information about the pretrial supervision program is located. So we're just in this one section. The bill is making changes to different parts of section 7555.
So Title 13 is your criminal justice.
Crime and criminal.
It's not DOC. DOC is Title 28.
So the first changes will be on page 2. And a few of these are kind of minor consistency points that we as Ledge Council try to make when we return to statutes to kind of reflect our drafting conventions that we use. So the change to line 2, changing from people to persons, that's a convention change from Ledge Council. And the change on line 7 from using a dash to saying and between these two subdivisions, also just a quick convention change. So you'll see those 2 edits. They're kind of technical things from Ledge Council, not implementing substantive things about the recommendations.
Okay, so I just want the committee to read quietly the purpose and aim, so you can understand what the program is. So please read it. Read the language, and it's at the top of page 2, what the purpose of the program is. But you really need to understand that in order to go forward. So questions on the purpose of the program?
No, I'll refer my question to different sets of testimony. I understand the purpose, just
Any questions? Are people clear on the purpose of the program? This is for folks who are not adjudicated. They haven't been sentenced. They've been charged.
Yeah.
They've been arraigned. They've either did not have bail set or they met bail. And it's a condition of their release. And we currently do not have this statewide. So now when someone they're not in Chittenden County, if they're released, they don't have this supervision.
even if they are in Chittenden County, it's only the accountability part, I believe.
Yeah,
So it's a small subset of Chittenden County.
the goal is to bring it out to the full state. Okay.
All right, moving forward. On page 2, we're looking at subdivision C. This talks about the pretrial supervision program and how DOC administers it. So the first change, substantive change, is on lines 11 through 13. Originally, this subdivision said that the pretrial supervision program shall be available to the 2 groups of defendants that I mentioned, that in statute, only defendants charged with violating a condition of release or who had 5 or more pending dockets could be referred to the pretrial supervision program. As I mentioned, that third Council of State Governments recommendation was to shift from the statutory categories to a process of DOC review, which you'll see more of soon. But the changes on lines 11 through 13 are just reflecting the removing the two statutory eligibility requirements.
So what is in section 8, except as provided in some subsection H, it wasn't G?
H, I believe, yes, H notes that if the program is not available, a court shall not order referral to it. So the way subdivision C1 is phrased is that the pretrial supervision program.
I got it. It was there to begin with, but we've added a section. So we've alphabetized them.
Exactly, that's the change from G to H.
Yep.
Did not flag that. Excellent catch.
That strike seems logical.
Hopefully that was a straightforward implementation of the recommendation. I think the committee can certainly hear testimony on the policy question of how to handle who goes to the program, how to prioritize them, how to identify them, how to refer them. Moving forward at the bottom of page 2, this is lines 18 through 19. This is talking about DOC assigning pretrial supervision officers to monitor defendants in the program. The bill would add that the department shall maintain a target caseload of not more than 20 defendants for each pretrial supervision officer. This is responsive to the first Council of State Governments recommendation that dedicated pretrial supervision program officers ideally maintain caseloads of not more than 20 clients. The Council of State Governments recommendation also implicates adequate funding for that caseload. This change on lines 18 through 19 just references the target caseload to try to reflect the policy from the recommendation in the statute, but different language would need to be added to address funding. Any questions about those first two changes?
So this is saying that for these folks, they're low risk. And that a officer in our field office, P&P office, would not have a caseload of more than 20. Is that a caseload of more than 20 overall? Is the 20 for other folks that they may be supervising that didn't go through the pretrial, that are not part of the pretrial supervision? You may not answer that. That's because they do have other folks that they could hire new people. Sometimes we'll have to get testimony from DOC on this, but sometimes they can add caseloads to folks who are currently in their field office. So would these 20 folks be new to their current caseload? Be one question. Also, there's statute that pertains to caseload ratios for folks who are P&P officers and their ratio for the caseload. So I want to look at that to see how this intertwines with that. So my question, these 20 defendants, is it the 20 specific from the pretrial supervision program? Or is it on top of what they're currently supervising elsewhere?
As I understand the Council of State Governments recommendation, it is a dedicated pretrial supervision officer, so only working with pretrial supervision defendants with a caseload of not more than 20. But as the chair points out, there are a number of questions that might be very interesting to hear from various witnesses about.
I remember the testimony when we were first setting this up. And in some counties, they might need a new person. In other counties, they could absorb it within their current staff. So if their current staff is already supervising folks, and we have to look at what's in statute about the ratios, because we put in ratios quite a number of years ago. So how this might impact it, might not. Folks, do you understand what I'm saying about the ratios?
Yep.
think I do.
How many folks one officer supervises?
Is this their whole workload or is this just an additional workload?
Well, it depends on the risk of the offender. If they're a low risk, they're gonna have more folks they're supervising. If it's a high risk offender, they're gonna have less folks.
In general, right? But this language.
The ratio language and clarifies what the risk level is of the
Right.
offender and what number of offenders per per officer, depending on the risk level of the offender. There's a ratio there. So the question here is if they're absorbing the pretrial officer within a current position
Yeah,
Right.
and they're subject to a ratio, how does adding 20 dependents impact that ratio?
And I'm happy to look at the statute and how it addresses the caseload ratio. That could be an area for the committee to consider if that is a more useful way to talk about caseloads. Many options going forward.
I just don't want to make a change somewhere and then you've got a problem in current statute.
Absolutely.
That word target also is, in my understanding, a soft term. You can be more or less, but that's what we're hoping for.
right.
Yes, I think the intent with this language is to reflect the policy recommendation that effective supervision can be done ideally with a caseload of not more than 20. All right, moving forward.
You know what, I gotta show my ignorance. I'm back on line 13.
Page 2.
Yep.
Page 2. We're striking not fewer than 5 pending dockets. I thought that was one of the conditions for participating in the pretrial supervision.
We're changing.
Under current statute, it is. So you are correct.
Right.
The Council of State Governments recommendation, at least as I interpreted it, you could hear from them again that they recommend tweaking this language, was to shift away from those kind of strict statutory eligibility requirements and to instead have it be based on DOC conducting a review of essentially, would this person benefit from pretrial supervision based on what we know about them, and refer the people who would benefit most to the program instead of those
I
statutory.
misunderstood the purpose, so, okay.
So it's a policy decision
I'm
for us.
back.
Exactly, yes.
Proposed, doesn't mean we'll do it. So where you see on lines 12 and 13 with a line drawn through the language, that's current law. So currently, for a person to participate in pretrial supervision, they need to have violated a condition of release pursuant to 7559. So they're already out on some conditions. And they violated some of those conditions, then they would be eligible for the pretrial supervision. Or they have not fewer, they have at least 5 pending dockets. So either way, so you may have some folks already out, conditions of release. They may not have had 5 dockets. And they violated conditions of release. So then the court could send them to pretrial supervision. Or a person could be coming before the court, they have 5 pending dockets or more, they could go to pretrial supervision. So there's 2 ways to get to pretrial supervision.
And ultimately, a policy question for the committee, hearing from witnesses, what's the best way to identify who should get referred to the program?
Mhm.
The statute originally said these 2 categories of people should get referred to the program. And one of the Council of State Governments recommendations was to think about that differently and to think about it instead of category-based, to go to kind of an individualized referral based on
Risk.
DOC reviewing. And DOC will be able to speak much more to how they currently conduct those assessments.
In its terms, we're making it more flexible.
Yeah.
I got it.
Eligibility.
I got it.
So a perfect question to clarify. Anything else before we move on to page 3? That is in fact a perfect segue to the changes on page 3. So previously, this subdivision D, we're on line 13, Subdivision D talked about the,
Oh, I think before we get there,
yeah,
Hillary, I think it's really important for people to know what 3 says, because you have to understand what level of supervision is out there to understand who's going to be supervised. If we make any changes, you have to understand what the level of supervision is. And 3 determines that.
happy to touch on that. So 3 is current law that remains unchanged, at least in this draft of the bill. And there are more details about this in DOC policy, but the statute lays out some framework. So subdivision 3, you are on page 3, line 1. The statute requires that DOC use evidence-based screenings for eligible defendants, and specifies that DOC's level of supervision might include DOC using telephone monitoring, telephonic meetings with a pretrial supervision officer, in-person meetings with the pretrial supervision officer, electronic monitoring, or any other means of contact deemed appropriate. So the statute kind of sets forward that framework. And then later in the statute also says, DOC, you need to go make some policies and rules about exactly what this is going to look like. But screenings have to be evidence-based. And here are some ideas for you about what kind of supervision levels might be appropriate.
So DOC determines the supervision level. It's not the court. The court sends them to the program. But DOC makes the decision on the level of supervision based on evidence-based screening that DOC will do. And then DOC will determine, based on that screening, what level of supervision. It could be very, very minimal, which is telephone monitoring.
I believe there are 3 levels currently. I believe that's what we saw in testimony.
3 levels.
Supervision, depending on the outcome of the screening.
Right. Right. It's more intense with more risk. It's more intense. But it's up to the Department of Corrections to determine the level of screening. It is not up to the courts.
Well, that makes sense because the corrections has the staff that do that sort of thing.
That's an important thing to remember. The court sends them to pretrial supervision, but it's DOC that determines the level of supervision.
How long have we been using evidence-based screening? Who developed that? Is it 50 years old or two months old? It changes.
Recent, because the pretrial supervision program was put in place within the last few years.
2 years, but DOC's been using evidence-based screening for
Right.
years. ORAS is the model that they use. They've been using it for years, but we can get DOC in and talk about their screening levels.
No, I mean, I assume that it's been tried and true, and so we depend on it. Therefore, we're going to make decisions on it. I mean, that's where I'm coming from. I'm just curious as to,
It's been there
I
a
don't
long.
understand the difference between A and B, department's telephone monitoring system and telephonic meetings.
One is they just check in through the phone, and the other one, they could do telephone meetings, like it could be through Zoom,
Ah,
could be more in person.
okay.
And then if they feel the person may be escalating, they could then do in-person meetings. So it's-
Got it. Got it.
But we can have DOC address those, because we took testimony from DOC to determine what type of supervision's out there, and that's why we listed those based on the testimony we received.
Great. That is a perfect setup to talk about the next section. So subdivision D talks about procedure. Under current law, some of which is stricken here, under current law, either the prosecutor or defendant or the court has to move for a certain defendant to be reviewed by DOC for whether it's appropriate to place that defendant in the pretrial supervision program. So DOC doesn't automatically look at all defendants under current law. One of the lawyers or the court has to request that DOC look at a particular eligible defendant to see if they are appropriate for placement in the program. Then DOC does their review, they report back to the court, and if the court determines that that placement is appropriate, then they order the supervision level that DOC recommended. Some of that changes with this bill draft. Remember that the third recommendation from the Council of State Governments was for DOC to review each of the possible eligible defendants, and then refer to or provide a recommendation to the court from there about who would be eligible. So this simplifies the procedure to, and now we're on line 19 on page 3. The Department of Corrections shall assess each defendant who is being considered or recommended for detention pending trial. And the department shall submit a report to the court containing recommendations pertaining to the defendant's supervision level. On page 4, lines 3 through 6, this is the other place that the statute mentions those 2 statutory eligibility categories, the violations of release or the 5 or more pending court dockets. So striking through that shifts us from having these 2 categories of defendants that could be eligible to DOC reviewing defendants being considered or recommended for detention pending trial and submitting a report to the court about their recommendations.
So right now, going back to page 3, procedure is that at the initial arraignment or any subsequent hearing, prosecutor or the defendant themselves can move or ask that they be reviewed by the court to determine if the person is appropriate for the program. The court can also ask themselves, but it is the court who determines whether the person is appropriate for the program. They do the review.
So the court still has, still holds a hearing and is the one that orders a defendant released to the pretrial supervision program. But instead of requiring one of the parties or the court to ask DOC to look at a specific defendant, this shifts from before getting a recommendation and the court reviewing and ordering it. This shifts to DOC reviewing any defendant who is being considered or recommending for detention pending trial and providing that recommendation.
So currently, once court has determined that the person is appropriate, or as the review, no, I'm interpreting that differently. As the court is reviewing whether or not the person is appropriate for pretrial supervision, right now, the court needs to get a receipt of a report from DOC containing recommendations pertaining to those defendant's supervision level. So DOC is currently already doing some of this.
Yes, I think there is likely a difference between how many screenings DOC is doing under the current procedure and how many that would involve under this new language. So that could be an area for the committee to consider testimony.
Yeah.
This removes a bit of a bottleneck that
Right.
we heard was in place because it just automatically requires, I guess, DOC to provide a review of everybody to the
Shall
court.
assess, shall assess.
Yeah.
And the way the current law is
Okay, ma'am.
written on lines 17 through 19, a review would be scheduled. A review of the person, whether or not they would be eligible for pretrial, is scheduled by the court, but the court needs to receive a report from DOC in terms of what the supervision level would be for the person.
And the court will still get a report from DOC. So one way to think about the changes in subdivision D, there was a little bit of kind of doubling up or repetition. It kind of prefaced it by saying, here's how the procedure will go. And once the court gets the report, here's what the court will do. These changes kind of remove that little summary of the procedure, since that's changing, or the initial kind of referral procedure. But if we turn to page 4 on line 7, this still includes, after hearing of the Department of Corrections report containing the defendant's supervision level recommendations, the court may order that the defendant be released to the pretrial supervision program, provided that the court makes these findings. And in making the determination, the statute also spells out what kinds of factors the court shall consider. So that part remains the same.
Right. So right now, the way a person would qualify or would get into it we're taking out at arraignment or subsequent hearing by the new language. And I'm kind of concerned about that because where else are they going to have the consideration of pretrial supervision? It's going to be an arraignment or a subsequent hearing because they could have violated a condition of release from a previous court action that would qualify them. So we're taking out at arraignment or a subsequent hearing. So how does the defendant even get to be considered? Is it just automatic?
So that might be an area to hear testimony from DOC. How would DOC determine who is being considered or recommended? The Council of State Governments recommendation didn't necessarily specify this. And I certainly appreciate that the relevant time periods will be arraignment and a subsequent hearing, but DOC isn't necessarily there.
Oh, they're not.
And so that's why the draft removes that language. But I think the chair's questions point out a potential challenge in what prompts DOC's review.
Somebody's got to notify DOC. So is it the prosecution? Is it the defense or is it the court? Somebody's got to notify. It's not going to be the defendant calling up DOC and saying, oh, I'm going to court. Somebody's got to notify DOC and DOC's not in the courtroom. Troy?
Well, and when does that notification occur? It should probably occur before arraignment so that DOC, as these defendants arrive to arraignment, DOC will have already conducted this
I
evaluation.
don't think they can. I mean, they do some pre-sentence reports, assessments that they're.
Pre-arraignment though, right? At arraignment,
No, it's
the
after.
judge is going to have to make a determination and then the prosecutors.
Pre-sentence, the person has already gone through an arraignment. I mean, the DOC isn't going to know a person's being arraigned the next day from being arrested.
Yes, unlikely that a screening could logistically happen before arraignment.
Okay.
It could.
I think the idea is anyone being considered or recommended for pretrial detention was the kind of category of persons that the Council of State Governments recommendation identified as being potentially most benefiting from having access to a pretrial supervision program.
Does
But
DOC get
Yeah, right. So arraignment is the first time
to go to court?
that this is the intersections could potentially happen. I'm just picturing a scenario or a practice, I guess, a protocol. Because they will have had interaction with DOC prior to arraignment.
No, not unless it's a condition. Not unless they,
We're going to get back into bail and
well.
or
They-
some sort of
some-
database.
Yeah, I mean, they don't have any dockets anymore. The way it is structured now, you've got to have violations of conditions of release. So a person could violate conditions of release. And that one, would it even include people who are on probation? Yeah, I don't think it did because it's pretrial, so they haven't been sentenced.
Right.
That's what I'm trying to
Yeah.
remember. So they were released at arraignment with conditions of release.
Mhm.
So they're not being supervised by anybody. And they violate whatever it could be,
Mhm.
you know, your curfew, or there could be an accumulation of things. You aren't supposed to be near the victim and all of that. So then they get sent back to court. DOC isn't going to know that because it's not DOC who violated it.
Right.
Yes,
it's
the,
local law enforcement or whatever. So that's one way into it. The other way into it is if you have 5 dockets or more, well, DOC might know something about it because maybe the person was detained in a facility and then went to court and then was released. So I'm just wondering how DOC, without any of those qualifiers to begin with, would even know prior to arraignment to do an assessment.
So, right, so this would require a DOC staff person to be at all arraignments.
That's not gonna happen.
Here's what I have from my notes of our January, I don't remember what date this was.
With Dave?
January 23rd. Yeah, with Council of State Governments. Referral and reporting process is what we're talking about, are not conducive to effective supervision process. Once we correct the referral process, we'll correct the log jam.
Mhm.
Current DOC staffing does not allow for the adequate supervision intensity for this population. That's kind of getting into the 20-person limit.
And the 5 dockets or more.
Right. And coordination across state agencies that serve this population must be stronger to provide the necessary services and treatments. While this is getting at, DOC should not be left holding the responsibility for all the wraparound services discovered during supervision, but that also gets to this coordination across state agencies gets to the fix that we're looking for here. How does DOC become aware of and when the people who are going to be qualified for pretrial supervision? So there's something that happens between arrest and arraignment that must be available information to DOC, isn't there?
I don't think so. I think it all happens
Unless they're detained.
unless they're detained.
So what kind of, there is none. There is no flag for folks who are arrested but aren't going to be detained that have a pending arraignment that should be evaluated by DOC to see if pretrial supervision is appropriate or necessary. I don't know what that
I
is.
don't know. So that's a question for.
It's that coordination across state agencies that we have to figure out. And it's not similar to the Vines mess, not dissimilar to the Vines mess. Various agencies talking to one another. And right, you should be able to input somebody upon arrest. This person is now in the system. Whether or not they go to DOC, whether or not there's a victim, whether or not there should be a statewide system. Right, and then DOC says, okay, these are all the people that are pending arraignment.
So it would be DOC shall assess each defendant who is being considered or recommended for detention. So to be recommended for detention means they're going to be a detainee.
That's what makes sense.
That's what it says.
Isn't that why the prosecutor was the one that initiated this request in the past?
It was the prosecution, it was the defense, or it was the court. There were 3 of them.
So they're aware of the risk, they're aware of conditions that says, maybe
No,
we can do something else. That's why they would initiate the request for pretrial supervision instead of incarceration.
well, they would let DOC know about it, and then DOC would do a review.
But
So there's
DOC
no-
doesn't have any information to do a review.
But then they would know the person and they could do some review. This is not even telling, this is assuming DOC knows the person right then and there, and they don't.
Right.
They don't. So
and this could be drafting. The current structure still comes from a court referral, and it's possible that the Council of State Governments recommendation envisioned that if someone is being considered or recommended for detention, that become apparent at arraignment or a subsequent hearing, and that at that point, the court would ask DOC to look at it. It wasn't spelled out in the recommendations, so it's not spelled out necessarily in this language, but that is something that could be, I think, an area for witness testimony, and could be quite answerable.
So what happens, and I'm looking on page 4.
Mhm.
This is current law, and I'm
Yes.
just recall. So where does the person go? Between the arraignment, currently, where does the person go? Between the arraignment and DOC doing the assessment and report? Person's gotta go somewhere. They're not gonna stay in the courtroom. And currently here on page 4, line 7, after a hearing and review by DOC. That's when the court can determine if the person's released to pretrial supervision. So where does that person go in the meantime? Because that report is not instantaneous. That takes some time.
Pretrial supervision is only currently available for folks who have been charged with violating a condition of release.
Or 5 pending docs.
Or
Or
five,
five.
right.
So
But they could be held.
So it's not
for
new
violation.
arrestees, it's not necessarily new arrestees, it's
But this
people
would
who
change it to.
have already violated.
Or have 5 pennies. Or have-
Yeah, but
With 5 dockets, they could be a new person into the system with 6 dockets.
we're taking that out, we're taking that,
Correct.
yeah, I know, I
Right,
know.
but
we're on
if
the
you take
same
this
page.
out,
Yeah.
but even with that, so if it's a violation of conditions of release, it's not somebody who's on probation, it's not somebody who's on furlough
When,
currently, is it? That's what I've got to check with you. I don't recall.
Eligibility is, I'm just looking at the slides right now. Defendants are eligible for PSP, pretrial supervision program, if they have been charged with violating a condition of release or 5 dockets that were taken out and pose a risk of non-appearance or harm to themselves. And that's what we're trying to get evaluated by DOC. Risk of non-appearance, harm to themselves or others. So, I'm in a mess here.
Yeah, I'm going around in circles right now because I don't recall. I mean, we were very clear when we put the language in, but the conditions of release that are violated, who does that encompass? Is my question. Because it's not, is it gonna encompass someone who's on probation? Because they've had a sentence. Or someone who's on furlough, because they have a sentence.
Not for that sentence, right? The only people getting referred would be for violation of pretrial supervision conditions, not.
And they're not under DOC.
Correct.
Currently, they would not be under DOC. Those violations of conditions of release would not be coming from DOC. They'd be coming from your local law enforcement.
Right. Currently, the kind of procedure works because what prompts the referral to start the whole process is a court hearing. So someone shows up for court hearing, not actually sure how the 5 pending dockets, I guess at arraignment, if someone says this person already has 4 other pending dockets, or someone comes in for a hearing on violations of conditions of release, then at that hearing, one of the parties could say, you meet the statutory requirements. Court, can you please ask DOC to do the screening and see if this person is eligible for pretrial supervision? So that's how the, current system addresses this problem, is that by definition, the people who are eligible, there will be a hearing at which they can determine and ask that DOC start the screening process.
we went a long ways from where I was starting, so. What just specifically about that question, that particular line, where it says. Oh, yeah. That the order that the defendant be released to pretrial, I mean, if they're being released, then they're detained in some way. So, because you're not gonna be released from your house or from the streets or wherever, you're gonna be in some kind of detention of some sort. Obviously, we don't have jails, it's the only place we have. Corrections.
Depends how you interpret be
Well-
released. They could be released from the court.
Well, right, and I was going down that road in a second, but you guys already did it, so.
I just, well, we gotta ask, we'll get the folks in here. Courts. prosecute. But I would think you've got,
There will need to be some triggering event mechanism that prompts DOC to start this review. I did not understand it to be part of the Council of State Government's recommendation, so it's not here. It doesn't mean that they don't have an answer to that or that the other potential witnesses could not suggest ways to do that. And again, it's a policy decision for the committee whether to pursue these kinds of changes.
I'm also worried about the fact that we're creating a linear protocol here that is dependent upon sufficient staffing that we just don't have at DOC right now.
Right.
So I don't have a problem with putting DOC at the helm of this recommendation earlier and exclusively, really. I have a problem that we're going to be asking DOC to do that and they don't have the staff to do that.
they may not have the history with this person. I mean, this person could come in with 6 new dockets that have never been arraigned before, never served time before. It could be 6 dockets because there could be 6 different crimes. And there's a docket for each one. The docket doesn't go. If the person is being charged with 6 different violations of statute, 6 different crimes, there's a docket for each one of those. It's not a docket for that person. It's a docket for those crimes. So a person could be coming in for the first time. Am I off base on that?
Well,
I mean,
I think timing wise, depending on how long it takes to bring them in for arraignment, it would mean that they have yet to be arraigned on any of their charges before they come in for the 6th one. I think I'm curious to hear testimony about how likely that is. But it seems likely that, I guess, under the current structure, it doesn't necessarily, well, I'll take that back. I'm not sure. I'm curious.
Well, we got to flag this as
Yeah.
a conversation with folks.
Yes, there are a number of trade-offs in trying to implement these recommendations
We're
as
doing it back.
the,
Yeah, we may be doing it backwards. James?
I would say, at any step of the way, it could be the first time that whatever entity sees you, right? The court sees you, the cops see you, DOC sees you. So that it's legitimate to think about. But what I wanted to say is support what Alice and Troy both said today is that my concern, other than making sure that the language is clear, is staffing. I think it's a huge issue. I'm very concerned about that particular part.
That's why
That's the middle part. So these are the 3 challenges identified by Council of State Governments. And I'm going to list them in the way that they have them, challenge 1, 2, and 3, and then encourage us to think about these in reverse. Challenge 1, DOC doesn't have the authority that they need to effectively do this. That's where we are right now. Challenge 2, resources and staff. DOC, if given that authority, don't have the staff to carry it out. Challenge 3 is the coordination across state agencies. And we're doing challenge 1 that still is going to require more staffing and coordination. Should we be starting with the coordination? Should we be creating some sort of centralized system by which once people are arrested, flag comes up at DOC and says, and then we'll know, is this the first docket, the second docket, the third docket? So once we have that in place, and then once we have DOC staff in place, then we can put them in charge of making these referrals to the courts.
So we'll flag it.
And I gotta go all the way back to the first question. What problem are we trying to solve with this? Because oversimplified, I think we're changing responsibility and loosening up. Yeah, we're changing responsibility, like you said, 3 things there, and we're putting more risk on the potential victims.
Right now, there's a lot of risk on the victims because there's no supervision,
So
period.
is
Because this
the
is
problem
free.
we're trying to solve, we have too many people we're holding
No,
before they're charged.
no, it's public safety. The issue is that people were cycling through. They would be arraigned on a criminal offense and they'd be released with conditions. And there'd be no supervision in the community. So it was a response to public outcry that community's not safe. they're reoffending, there's no supervision.
So adding some, okay.
That's what the pretrial supervision program came about. To provide supervision for folks who have not been convicted. They are innocent. They've been arraigned on their charge.
So we're not loosening up, we're actually tight.
We're tightening, which then in effect, because now you've got DOC out there supervising them, which puts pressure on DOC, and they're not under the custody of DOC. They're not under the custody per se of the court, they kind of are. It's a violation of any of those conditions, they go back to the court. They're not under DOC, but we're asking DOC to do the supervision.
You'll remember that some witnesses had shared that, for example, the federal pretrial supervision program, which I think the witness said was well thought of, is run under the court system for perhaps for some of these reasons.
Probation is usually done under the courts too. For
In
supervision.
most states, right?
Yeah, but we go to DOC. So let's flag this. I'm looking at the time. We need to keep moving.
May I ask one more question? Is it reasonable to understand the criteria that would be used, that would come out of evidence-based screening? Is it a checklist?
We'll get
Is it-
into that with DOC on this.
It's on the slide to
But the short version right now, that nobody's in this program. We're hoping some people will be in the future.
Yeah, we got only one person who's been.
We're trying to address
Well, might be two.
why people aren't in the program. That's what we're trying to address with the language changes to have it more readily available to folks. So that the court, the defense, and the prosecution can agree that the
Mhm.
person should be on pretrial supervision. Sometimes the defense doesn't want folks to go there because it may indicate that, yes, they're guilty of the crime.
So
So that's the balance that's at.
Or alternatively, they just be outside with no supervision, which is what's happening. So why would they agree to it?
Right.
we
Okay.
just had, Joe and I in the hallway with Vince, of all people, had a conversation the other day of somebody who just went into this. And we were like, well, can you tell us more? By the way, he's happy to come in and talk. I was fascinated. I learned more in that conversation than I
He's a state prosecutor.
yeah, but we're like, well, why would somebody agree to this?
Right.
And the terms that were being offered were more, they were still like supervisory in a way. I don't remember the details, but they were more, because pretrial supervision was less stringent than what was being offered. It was an early option. You know, so like, but most of the time it's more stringent than what they're being offered.
Scenario he referred to was somebody whose choice was pretrial supervision or 24-hour curfew.
Yes, that's right.
And so they chose.
Curfew.
No, they actually took the,
Pretrial?
basically, they took the pretrial supervision, but in his
Sure.
experience, that was an outlier. It
Yeah.
usually doesn't. But it's usually pretrial supervision or out with conditions and no supervision. So, I mean, a reasonable person isn't gonna, why would you agree to
It's
supervision?
just an interesting anecdote.
They're gonna go with the least restricted.
Yes,
Yeah, I mean,
Period.
that's,
It's gonna go with the least restricted.
I would.
Anyone would.
Yeah.
Yeah.
Well, Kevin might not.
Yeah, I like pain. That's why I'm here.
There's no way to segue, but on page five.
There's no segue.
It's like there, yeah, I can't, I won't even attempt. Page 5, lines 12 through 14. I guess starting on line 2, this is a section that talks about compliance and review. So you'll remember that currently, if a pretrial supervision officer is aware that the defendant has violated a court-imposed program condition, then the pretrial supervision officer has to notify the prosecutor, who can then decide to notify the court. And if it's a violation of a department-imposed administrative condition, then the pretrial supervision officer may, but does not have to notify the prosecutor. Either way, the chain of communication goes from the pretrial supervision officer to the prosecutor, and it's up to the prosecutor to decide if and when to take that to the court. The suggestion from the Council of State Governments was that pretrial supervision officers be able to go directly to the court if a defendant has violated a court-imposed program condition. So lines 12 through 14 specify that a pretrial supervision officer or pretrial supervision officers may file a motion to review pretrial supervision conditions for a violation of court-imposed program conditions committed by the defendant. I will note that this is the only change in the House bill.
Yeah, but the governor wants a little change. in this. So the governor's proposal is on line 3, compliance and review. Pretrial supervision officers shall notify the prosecutor or the court. These reasonable efforts. And that's also true. Line 6, pretrial supervision officers may notify the prosecutor or the court. So that's what the governor's language says. Okay, and then
So are we contradicting that with B?
I don't know. I mean, this is just, I'm reading what the governor has proposed that they're working on, that they have in this
Well, current staff,
judiciary committee.
oh, yeah, that's,
What House bill is that, Alice?
712. But they're using 5, whatever it is.
So the language on 529 is just line B. I'll have to go look at the other.
There's the governor's recommend that I'm working with. Okay,
but doesn't it?
I think there are two ways.
yeah,
It's slightly different. So there are two ways of getting a similar result. The difference is the language that the chair just mentioned would mean that a pretrial supervision officer, if a defendant violates a court-imposed program condition, the pretrial supervision officer has to notify someone. They can choose if it's the prosecutor or the court, but they
Yeah.
can't. I guess that's true under. Interesting. They really get at the same thing. I
Different.
think you could argue that
differently.
it's not clear. Yes, they reached the very similar results.
In this
Thinking
bill,
through
though,
that.
doesn't lines 12 through 14 contradict lines 3 through 5?
It does. It does.
In what sense?
There's a shall,
Well, it's more-
pretrial supervision shall notify,
But it shall notify the prosecutor.
right, and,
And
Oh, so-
may notify the court.
okay,
May notify, so it's as currently written, good question. Pretrial supervision officers still have to notify the prosecutor if it's a court imposed condition.
but we're giving.
May notify the prosecutor
Okay.
if it's a administrative DOC condition. And may go straight to the court if it's a
Okay.
court
But they
imposed.
still have to
condition.
notify the prosecutor.
But this B, lines 12 through 14, does not apply to lines 6 through 8.
This is why it's not
Correct.
being used, it's too complex.
No, this is proposed language change.
You know.
Yes.
So this hasn't been
The
implemented.
Program pre-trial supervision is in place, is it not?
Right, but we're talking about the proposed language
Understand,
change.
but it's not being used because it's so complex.
It's not complex yet, this is.
It's not, we're making it more complex.
To
Yeah.
the chair's point, I think there are two differences between the proposed language. The first is that under what I understand to be the governor's language, pretrial supervision officers would notify the prosecutor or the court, have to notify either the prosecutor or the court, whereas the new added B in the bill would say they have to notify the prosecutor and they may choose to also notify the court, but do not have to. So slightly different. I think if the governor's language said and or the court, that would be the same result.
There's another qualifier on line 13, violation of court-imposed program.
Yes, and that's the second difference, I think, which is that under B would not allow pretrial supervision officers to file a motion for the court to review a violation of conditions that DOC imposed.
Right.
Whereas what I understand to be the governor's language would allow the pretrial supervision officer to choose to notify the prosecutor or the court if there were a violation of DOC imposed.
Because an example of that we heard during the testimony, if the person's on electronic monitoring, there are DOC requirements for being on, for electronic monitoring in terms of either you get a check with the person or you keep your bracelet on. If they violate that, they take their bracelet off. That's not a violation of the pretrial supervision program. It's a violation of DOC requirements that go along with that electronic monitoring. So that's why we had that differentiation in there. So these are the layers that you pick up as you hear testimony and you work language in a bill for this. James?
Way back on lines 3 and 6. personally, I'd like to know why the recommendation by the administration is prosecutor or court. But I also at the same time, just on a visceral level, don't like it because you're taking one avenue, which is pretty simple. You always know it's going to be the prosecutor. And then you say, oh, but it could be the judge.
Well,
You
the
know,
prosecutor may not go to the court. That's the issue.
that's a part too, but that's where I think it should, if you're gonna add it, it should be and, not or, because then it's going to one, we're gonna go to the prosecutor. Oh, well, we choose to go to the court. And then you get this whole big mess now. I do agree that you might not talk. Prosecutor might go, oh, I found this out, tell the court. Great, cool. But it should be and, so that they both are getting notifications, not or. So one case goes to the court and one case goes to the prosecutor, and you're like, who knows what?
We're not there yet
I
in
know,
making
but-
those decisions.
I know,
That's
but-
based on testimony that we're gonna be receiving.
I mean, but in fairness, there's a lot of things we talk about that we haven't got there yet, and I just want to put it out there while I think of it, because I might forget.
So it sounds like the committee has at least two possible avenues to think about making language changes to this section. But the core idea here is providing some mechanism in some circumstances, whether it's mandatory or permissive, and whether it's in addition to or an alternative to the current structure, but for pretrial supervision officers to be able to go to the court to notify them about at least court imposed conditions, maybe also DOC imposed conditions. Any questions about those changes on page 5?
No, but there's more changes on the governor's recommend. I'll sit down with you.
I'm not aware of that. Wow. So not yet familiar with that statutory language.
You know who got?
I don't know who drafted this. Would it have been Michelle?
Someone on the judiciary team, certainly.
Yeah, there's quite a bit of change. Number 4, there's quite a bit of change. The governor's. Go over that. I don't want to take committee time because we need to get to lunch here real quick. So
I'll go over the one change on page 6, or I guess the 2 changes, but one new one. Yes, my mandate in presenting this was to take the Council of State Government's recommendations and put them in bill form for discussion. My understanding is
you did the good thing. Don't worry
awesome,
about it. You did
prompting
fine.
plenty of discussion among the committee.
Fine.
And I understand that the House Judiciary Committee has another pretrial supervision bill that contains some of this language, really just the language on page 5. And it sounds like there is another bill that contains administration language.
Yeah.
So to make sure you can go eat, which is the best thing and important. On page 6, on lines 6 through 7, this goes kind of hand in hand with the changes on page 5 about allowing pretrial supervision officers to go to the court. This would say that DOC shall develop criteria for motions to review pretrial supervision conditions, basically give pretrial supervision officers a kind of consistent criteria to reference and when they choose to go to the court on court imposed conditions. Again, this was one of the parts of the Council of State Government recommendation for uniformity, as I understand it. The change on page 6, lines 8 through 11, this is a new subsection G. Previously, the contingent on funding was subsection G. That moves it down, and there's this new subsection regarding coordination regarding behavioral health services. And this speaks to something Representative Hedrick was mentioning, that a core part of the Council of State Government's recommendation was to improve coordination across agencies. I think in a variety of ways. This one addresses coordination across agencies regarding providing behavioral health services. And the Council of State Government's recommendation was specifically thinking of referrals to community-based providers. But subsection G would add language that the Department of Mental Health and the Department of Health shall coordinate with the Department of Corrections to provide timely referrals to behavioral health services for defendants supervised under the program. I think there are questions that the committee could consider taking testimony on about, you know, where are the bottlenecks in this? Is it in the availability of the programs to begin with? Is it in how referrals happen? There might be different aspects of what coordination could improve, but this language at least implements the policy recommendation that these agencies should be coordinating on these topics toward the goal of providing timely referrals for defendants who are in the program. Any questions about the changes on page 6?
Got a lot of work ahead of us.
Wow.
Got a lot of work ahead of us.
Especially lines 3 and 6.
There's a lot more.
I know.
There's a lot more work. So what I would like to do, Hillary, you and I need to chit chat. Because I'm trying to figure out, do we want to complicate the things with the governor's recommend? Because the governor's recommend, so there's some more changes here that are really different.
I am happy to implement whatever the direction of the committee is. I just am aware that House Judiciary is taking up the same topic next week. And so just want to make sure that whatever coordination is helpful to have happen happens.
Because I'd like to get a draft out there. We want to bring folks back like on Wednesday, right?
Yep.
So I'd like to get a new draft out there if we're going to incorporate the governor's recommendations as well. And I don't know if that would complicate it or not.
It sounds like at least one of them is potentially in tension with at least the way this draft implements them. So I think it would be a conversation about which path the committee would like to take. But I'm happy to take the committee's direction on preparing an amendment if there is a direction for that.
Will we be having someone sit in when judiciary takes testimony?
You could, I'm just not there yet. I'm just trying to figure out for us the next step. Because judiciary is going to look to us for the language. They're just going to become familiar with the program. So why don't you folks go to lunch? We're back here at noon, right? Why don't you folks go to lunch? Hillary and I will talk. I'll show Hillary some of the other language.
I'm happy to look at it. I will just need committee direction about when we're implementing it and
Why don't you come on down? And so for folks on YouTube, we're going to be back by 12 o'clock. So we're going to take a quick lunch. Okay?